Jamaica. Make we do the right thing. Make we live good today for a better tomorrow. Talk it out. Don't fight it out. The time by the Ministry of National Security is
6.
The issue of privacy and dignity is once again in the spotlight. The Jamaican Bar Association is voicing concern about the release of sensitive details surrounding the death of Judge Ruth Lawrence, warning that it could violate the Data Protection Act. At the same time, public discussion around the case of a senior executive at a prominent commercial bank facing charges in connection with a sexual assault-related offense involving a female employee raises fresh questions about how we treat sensitive matters in both the media and society at large. This is Lead Story. Good evening and welcome to Lee's Story. I'm your host, Joel Crossgill. Tonight, the discussion turns to the broader issue, how privacy and dignity are protected when sensitive cases enter the public space. It's a conversation about rights, responsibility, and the impact of commentary. We've prepared this package for you.
A senior executive at one of Jamaica's largest banks now finds himself before the court on serious sex-related charges. Court documents and law enforcement sources confirm that head of the fraud prevention unit at the National Commercial Bank, Dane Nicholson, has been charged with 6 counts of rape and 2 counts of grievous sexual assault. The allegations stem from incidents said to have happened more than a year ago at the home of the complainant, who's believed to also be an employee of NCB. Now, news of the case has ignited mixed reactions in the public domain. Now, Mr. Nicholson's attorney, King's Counsel Peter Champagny, is however condemning what he describes as a trial in the court of public opinion.
And the consequences of that is that very often, if it involves a jury trial, it will be difficult for a case to get a fair hearing because you'd have constituent members in a community who, based on information that is circulated, would have perhaps formed a particular view already without hearing one scintilla of evidence, and that can't go well for the justice system.
Now, he didn't specify if in this case the matter would be tried before a jury. However, in the Jamaican justice system, most serious criminal offenses such as rape are heard in the circuit court before a judge and a jury. Now, Mr. Champagny says the impact of the case extends beyond the defendant.
For the complainant, there is added pressure because sometimes, in social media spaces, persons are wanting to find out who exactly is this complainant, and all kinds of comments are made, and it doesn't go well for the justice system. And my point is simply this: yes, I appreciate the principles regarding freedom of information and the right of the public to know and to be informed, but there are certain guardrails that we need to be mindful of.
Now, Mr. Champagny is also taking issue with the publication of the accused's name and photograph.
When you look at things like these and you have a result where the person is vindicated before the court, how do you rebuild from there? How do you pick up the pieces and move on? So all that I'm saying is for there to be great caution to be exercised in treating with such cases that are arising.
Mr. Nicholson, who is now out on a $1.2 million bail, is expected to return to court on November 24.
Amoy Harriet with that report. We're on our first break here on Lee's Story, after which we'll hear from our guests.
Get ready to take flight. It's Aviation Expo 2025 in collaboration with the Airports Authority of Jamaica and the Jamaica Civil Aviation Authority, the island's ultimate aviation showcase and family fun day. Join us Saturday, October 4 from 12 to 8 p.m. at Tinson Penn Aerodrome in Kingston with show host Ian I.T. Ellis. And guess what? It's free. Plus, the JCAA and JDF will be recruiting. Follow at Aviation Expo JA for updates.
Thank you for staying with us on Lead Story tonight. We're talking about how privacy and dignity are protected when sensitive cases enter the public space. Our guest tonight, our former president of the Press Association of Jamaica, Byron Buckley, and attorney at law and data protection expert, Chuck Cameron. Good evening, gentlemen.
Good evening,
Good
sir,
evening.
and your listeners.
Thank you so much for joining us this evening. All right, we're going to get right into it, starting first with the distinctions between what's in the public interest and what the public are interested in. Do you believe there is a distinction between those two things? I'd like to start with Mr. Buckley.
Yes, there's an expression in law, certainly public policy, called the public good. But for media, you have the public good, but you also have, from a news perspective, what the public is interested in. And I think the media have to balance both things. But in most cases, what governs is what the public's interested in. You don't want to put out news or information that nobody has an interest in. And so in most cases, and then that itself now has some different rules and logics. So yes, there are two things. There is information that the public is interested in, and there is information that for the sake of the public good, you should not withhold.
And Mr. Cameron, what would your assessment be of the distinction between those two things?
One, there is an objective standard in which one can discern the difference. So when we speak about in the public interest, that is tied to, for example, the discharge of a public function by a public authority or someone acting as a public authority, and or it has impact on how the Jamaican citizen can enjoy the rights that have been guaranteed under the Constitution. Where a matter of public interest is what is topical, what is trendy, and that's fleeting in comparison to that objective test as to whether or not you could tie the issue to some fundamental matter that touches and concerns how the government discharges its responsibilities and how some action impact on the public at large. So it would be ideal, especially for media houses where those two coincide, but one is more a poll and how people feel over time can change, but what is a matter of public interest remains consistent. But I've never addressed my mind to that question, but there are two discrete issues.
All right, now I'm trying to establish our terms of reference here. So I want to also make the distinction between a public figure and a private individual in the social media age. All right? So Mr. Buckley, how would you say that distinction is being blurred?
Well, first of all, let me establish that even before the social media phenomenon, that you have public officials, and I'm going official wise now, meaning that by nature of your job, state, and so on, you're going to be there. People are going to be interested in what you do, but yes, you also have a personal life. and there is a line to draw. But if somebody is a private person, you're not a public official, you're not elected, you're not even an entertainer, because some of those are prominent people. You're a public personality. You're none of that. So you have a personal life. But if you are any at all a public official or a prominent person, say you're in the entertainment industry, it's going to be difficult for you to claim the same right or privacy that I have when I'm involved in none of those things. It's difficult, because by the nature, one of the logics of news is that people are interested, the more public your life is based on your position and so on, the more interest people will, and it's not necessarily a bad thing, the more interest people want to having you and know about you, because you have a public life too. But I didn't answer your part about social media, because I think that is the same thing social media simply aggravates.
Well, we're going to get a little more into that a little bit later. I'd like to bring in Mr. Cameron again on this particular aspect of the debate of the distinguishing, or being able to distinguish between a public figure and a private figure, particularly when people have social media followings that could be huge.
So the premise or the relevance of that question, which distinction, which is again a very important distinction to make, is that privacy, the concept of privacy is interpreted by the court to say, what is my reasonable expectation of privacy? Regardless of whether you are a public figure or a private figure. If it is you live in a public manner, and you publish your life on social media, or you are a public official and you're in the eyes of the traditional media, the level of expectation of privacy would be diminished. So just to be clear, whether or not, even when you're a private individual, if it is you consistently publish yourself and put yourself on social media, your expectation of privacy will be diminished, because you invite people to scrutinize you, and you invite people to scrutinize you. So in this instance, both of them are the same for me. Your expectation of privacy should be much lower than an individual who does not live their life on social media and not a public official. I hope I've been able to convey that nuance for you clearly.
Yes, you certainly have been. I expect that we'll get even further into the nuances associated with this conversation, probably on the other side of a break. But before we go to the break, I'd like you to mull over where I intend to take it next. And it includes the technology of social media and how people are the proliferation of these digital tools, and the consideration of what is newsworthy, in terms of how people interact with information and how they interpret it as being newsworthy on that platform as opposed to a traditional broadcast platform. So we'll explore those topics on the other side of this break. This is Lead Story.
To take flight. It's Aviation Expo 2025 in collaboration with the Airports Authority of Jamaica and the Jamaica Civil Aviation Authority, the island's ultimate aviation showcase and family fun day. Join us Saturday, October 4 from 12 to 8 p.m. at Tinson Penn Aerodrome in Kingston with show host Ian I.T. Ellis. And guess what? It's free. Plus, the JCAA and JDF will be recruiting. Follow at Aviation Expo JA for updates.
Here at Extreme E. This is unbelievable. replace pain. Peace can replace turmoil. Hope can replace sorrow. God loves you. God hears you. God speaks to you in your thoughts, in your heart, and through living prophets. Come, hear the words God has for you.
Welcome back. This is Lead Story, and we're exploring the tension that exists between the public's right to know and the individual's right to privacy. Still with me, attorney at law Chuck Cameron and former president of the Press Association of Jamaica, Mr. Buckley. All right, so I said we're going to get into it a little bit now. So one of the distinctions I believe Mr. Cameron would like to address is even after death, do you believe that privacy concerns continue? Are they maintained? Are those rights maintained?
I don't believe so. But that's not what the Data Protection Act says. I believe constitutional rights are only enjoyed by Jamaican citizens that are alive. However, our Data Protection Act extends privacy protection to those persons who have been dead under 30 years. But you asked me the question, do I believe that rights should be extended to them? No.
No, categorical no. Mr. Buckley?
Yes.
Should media professionals concern themselves with the court of public opinion ahead of writing their news items?
That's actually a question. The answer could be yes or no. But basically, when you're writing a story, you write the story based on the facts surrounding the story, not what you think people think about it and so on. It's really the facts, the objective information surrounding the event or story when we're writing about.
So you shouldn't really give any thought to the potential aftermath of the information that is released. Even though it's factual, it may be sensitive, and it may have an impact on those related to the story.
Well, listen, writing news has some basic logic. Something happens to be news because it meets some objective criteria. And I was about to, if you had come back and asked me that question after the break, I would have told you that whether it is on social media or traditional media, the factors that makes a story newsworthy remains the same. All social media does is to amplify it. And so when you're writing a story, you think about is it something that affects the audience, whether it's a local audience or an extended audience? Is it about somebody who's prominent? We learn that about man bite dog and dog bites man. And there's some other criteria that determine what a news story. It really isn't about whether or not the person you're going to be writing it about or groups or organization like it or not. That's not how you write a story. Let me just back up to say, in addition to the rules of the logics of what news is, there is the whole matter of the law of defamation. You're certainly liable. You certainly bear it in mind because you don't want to purposefully, deliberately defame anybody. And of course, there's accuracy. You don't tell lies and so on and so on. But there's an area that is subjective and discretionary, and that is the whole matter of taste. And so to answer your question, taste depends, yes, to a certain extent, on the society that you're in. And so you can disclose something about an incident in the USA. Just use an example, in the USA. But if you're in a more conservative country, say Jamaica or say Barbados, disclosing that information could end up being considered poor taste. So yes, journalists and their editors have to also bear that in mind. So I would answer your question that way to say, yes, there are some concerns about good taste that you think about when you divulging some information.
It brings to mind, I think I'm paraphrasing here, but it's Shakespearean in terms of discretion is the better part of valor.
Exactly.
In the context of modern media, especially as it relates to individuals in moments of distress, how broadly can distress be interpreted? I'd like to put that towards Attorney Cameron.
So, from a legal perspective, for one to successfully bring an action under the Data Protection Act, if we were just to jump straight to the damages part, you are required to be able to demonstrate that you have suffered some sort of damages. And when we are speaking about processing personal data or publishing sensitive material, that the damage that is usually suffered is some sort of emotional distress for you, and that is measurable. And for one to succeed, one does have to go before a professional, a doctor, a medical professional, who can determine the type of distress you have suffered, and it must be supported by a medical report that speaks to that distress. So the whole question of distress can be manifested in a medical report. So it is something otherwise that is tangible, that is necessary for you to bring an action under the Data Protection Act. It is something real.
I know in the past.
I want to hasten to say that the Data Protection Act actually make an exemption to. There's a grouping called special purpose, and journalism is mentioned as one of the areas that you could use you could reference some stuff that are exempted for disclosure for the purpose of journalism, and I think that we have to be aware of that too. Journalism is a special, should I say, profession, a special discipline, and there are some exceptions, just like how some lawyers, lawyer-client privilege. There are some privilege that journalism has if you want to serve where you started with the whole matter of the public interest and the public good and so on. So there's that exception in the Act, special purpose of journalists.
I'd love to clarify that, if I may.
Okay.
When we speak, the exemption that it speaks to is a specific type of data controller, in this instance, a journalist, not being required to comply with the one part of the first data processing standard that says if it is you are investigating a subject, you don't have to you are exempt from notifying them that you are conducting some investigative journalism. So just want to be very clear, it's not that you're exempt from the Data Protection Act. There are 8 data processing standards, an entire framework. That exemption is very limited in scope, and it's very practical. It says that if it is you are doing some investigative journalism on me, you don't have to give me a notice and say, Mr. Cameron, we are investigating you. On the other hand, a normal data controller that's not a journalist or media house or not the police, as long as you have their information, you have a duty under the same first data processing standard to inform them by way of a notice to say, we have your information and this is what we're doing with your information and this is why we have it. In your case, at the end of the day, you don't have to, let people know that you're investigating them, and you don't have to disclose your sources.
All right, Mr. Cameron, I'd like to interrupt you right there because there's a topic I want to discuss in the remaining time that we have. In terms of the differences between professional journalists, professional broadcaster, news houses, and the people on social media who have been encouraged to become citizen journalists. So one of the restrictions in terms of the news cycle is, for instance, right after this program, we will have our evening broadcast at 7 o'clock. It's not a 24-hour news cycle in terms of being an on-screen presence with news, as opposed to social media where information can come out at any time. In traditional media, we're encouraged to do our checks and balances. We're encouraged to reach out to the sources themselves to establish veracity of the information that we've received. I'm not too sure if the online journalists have a similar standard to operate by. So how is it that the media sometimes reacting to stories that are broken online with information that they themselves may not publish, but then end up having to clarify that information? How do you suggest we address that challenge? And I'd like to ask Mr. Buckley to address that first of all.
Well, again, as I said before, the rule doesn't change irrespective of the platform, because if it is that traditional media got wind of should I say a news story via social media, their job still remains. They're going to have to still do the same, the correct sourcing and all of that before they can put that story out as a bona fide story. So the rules still apply, never mind where you saw it first. In other words, I don't equate citizen journalism to journalism. Citizen journalists don't need to check any source or anything. They go ahead and print something. Traditional media can't take that as a real story. They take it as a lead and then go and pursue the story correctly. And then they can publish it on either media. So that's the approach I take to it. You can't